anytime. Criminal procedure will be moderated by Cesar Rosado Marzan, the Monk's Cafe Chair in Socio-Legal Studies at Yada Yada Law School and a professor of law at the University of Iowa College of Law. And constitutional law will be moderated by Guha Krishnamurthy, the Jacopo J. Peterman Chair in Jurisprudence and Fashion Design at Yada Yada Law School and an assistant professor at South Texas College of Law. And now, without further ado, it is my pleasure to introduce Professor Jordan Carr Peterson, Jackie Childs Chair in Constitutional Criminal Procedure at Yada Yada Law School and Assistant Professor of Political Science at North Carolina State University to teach Seinfeld criminal procedure. Professor Peterson, over to you.
All right, thanks so much, Greg, and thanks for everybody being here. And I hope we have a good time today with our doubleheader going through different facets of actually what ends up being mostly two different avenues of constitutional law. One focused more on the procedural aspects of criminal litigation, and then what Anthony will talk about subsequently, which takes us in a different direction. So before I get started, again, to introduce myself, my name is Jordan Carr Peterson. I'm a political science professor at NC State. And before we get started with the substance of today's lecture, I wanted to remind everyone, if possible, to donate to the charity that we've chosen to benefit from this outing that we've all kind of collectively embarked on this summer, which is the legal services relief in New York City related to the coronavirus. So you can find more information on this on our website and also in the PowerPoints here. And I'll have another kind of wrap-up slide at the end, including this too. But this is an important cause that we're all dedicated to, and we're happy to be doing something that can at least in some way ameliorate some of the suffering that's going on. So to get started, again, a quick introduction about myself. We already know most of this. If you want, follow me on Twitter. The information's on there. And I think one thing that is unique about my perspective on some of this, which might not change too much of the analysis that we ultimately hear, but I think I'm the only person here that's not a law professor, right? Which, for better or for worse, I have a background in law. I got my law degree at University of Florida, but I have been as an academic in political science departments studying political and legal institutions, kind of the operation of policy implementation, as well as economic representation in public affairs and public institutions. So it might give me, in some instances, a different perspective on things, but in all likelihood won't really affect the way that we go about our day-to-day analysis and consideration of these issues. So with no further ado, what we're going to do today is go through quickly what is criminal procedure? How does it differ in particular from what we're going to have another lecture on later in this summer semester, criminal law? And then getting the really fun stuff where we're thinking more carefully about how Seinfeld fits into all of this. We want to think about what the police are permitted to do in the context of an interrogation. So this is a particular phase of a criminal investigation that we see for those of you who are familiar and did your homework from the syllabus in the two-part episode, The Trip, in which Seinfeld, as it very rarely did, took itself out of Manhattan, out of New York City, and came out to where I currently am on the West Coast, and spent 2 episodes in Los Angeles, which involved one of Kramers' many legal misadventures. We're going to think about the investigation and interrogation surrounding Kramer in the context of the Smog Strangler investigation, and whether there's anything explicitly or implicitly that the police officers, the law enforcement did in the Trip episodes that might call some of Cosmo Kramer's constitutional rights into question. And last, to narrow in a little bit more specifically on one particular tool that law enforcement uses in the context of a criminal investigation, we're going to think about the constitutional standards governing lineups in police practices and what sorts of standards do police have to adhere to in constructing a lineup as they're investigating alleged prohibited activity. So to get to this first question, just for those of us who don't necessarily have a background in the subject matter, whether it's law, whether it's criminal justice, we have this overarching question of what exactly is criminal procedure. So I think the common misconception is to equate criminal procedure as a subdiscipline of the law with criminal law. And the main difference between the two is that whereas the one, criminal law, concerns itself with determining the legal components of a crime, so what are the substantive elements of different criminal activity, what are the substantive components of determining criminal intent to commit such activity. Criminal procedure is more concerned with the series of operational standards governing police and prosecutorial conduct in the context of a criminal investigation. So these are things that, and one of the things I want to kind of hammer home over the course of today's hour that we have together is that in the popular press and in the popular imagination, I think the most common tendency is to associate procedural rules such as these with mechanisms that allow the criminally accused to get off on a so-called technicality. And what I think the most important thing to establish is going forward today is that what's popularly conceived of as getting off on a technicality actually involves the protection and the enshrinement of really, really important constitutional principles that we have given the criminally accused since the foundation of the Republic. So this is kind of the throughput underlying all of today's discussion. And of course, we can't even begin to breach all the different components of criminal procedure in today's lecture, but in considering the constitutional privilege against self-incrimination and thinking about the constitutional standards governing police lineup practices, we can at least begin to chip away at this veneer of what exactly the police are permitted to do, even while they're investigating conduct that society generally might agree overwhelmingly should be illegal. It doesn't necessarily mean that law enforcement and prosecutorial staff can do whatever they want. So to just give you a little bit more idea of the sort of variation that we see, we have constitutional criminal procedure, which is mostly what we'll be talking about today. This involves the protections that criminal defendants are afforded, and suspects as well, not necessarily formal defendants, are afforded pursuant to the 4th, 5th, 6th, and to a lesser extent, but no less importantly, the 8th Amendment. It doesn't come up too much that, in an actual class that you'll take. Most of the class time is devoted to the 4th, 5th, and 6th Amendments. So this, of course, includes things like the protection against unreasonable searches and seizures. So this is a sort of, privacy right that we have in our persons, houses, places, and effects. The 5th Amendment, in addition to a broad guarantee to due process, which is just a way of saying fairness if any criminal proceeding should be initiated against you, it also includes the privilege against self-incrimination, which we'll be talking about in the context of interrogation, and in particular, the different sort of legal standards that we've inherited from the Miranda versus Arizona decision in the mid-1960s today. And as well, the 6th Amendment provides the criminally accused the right to counsel, so the right to be assisted by legally competent representation should they be formally charged with a crime. And we'll talk a little bit in the lineup context, and maybe a little bit in the interrogation context as well, about when exactly a criminal defendant can claim that their right to counsel has attached or is relevant. At what stage of the process do you have the right to an attorney? Because it seems in the abstract, like we should always have the right to an attorney, but for criminal procedural purposes, there are very specific standards governing when the right to counsel has formally attached to the criminally accused. Just in the interest of thoroughness, in addition to constitutional criminal procedure, we also have at the federal level and at the state level, what I'm calling, for really lack of better terminology, statutory criminal procedural rights coming from the federal rules of criminal procedure. So I think the easiest way to sort of rule of thumb to differentiate the constitutional from the statutory aspects here is to think that the constitutional standards, the 4th Amendment protection against unreasonable searches and seizures, the 5th Amendment guarantee to due process, privilege against self-incrimination, 6th Amendment right to counsel, those are broad conceptual rights that, due to the inherent vagaries in the language, we've really relied on them being judicially constructed or having their contours and silent portions filled in by court activity, really for most of the history of the United States, but in particular the 20th and early 21st century. On the other hand, a way that the federal judiciary has filled in some of these interstitial gaps that the broad constitutional protections afford is by the promulgation of the federal rules of criminal procedure. So these have been enacted by really the Supreme Court, the federal judiciary, but Congress enacted a statute in the mid-1930s called the Rules Enabling Act, which allowed for the federal courts to come up with rules governing civil procedure, another class that we'll have in our series of lectures this summer. And due to the sort of, resounding success of the federal rules of civil procedure, the Supreme Court was subsequently authorized to come up with a uniform set of governing standards for procedural rules in the federal criminal courts as well, which is how we got the federal rules of criminal procedure. The first iteration came out in the 1940s, in 1944, and they're updated really annually ever since. So these govern very specific standards of how federal crimes should be investigated and prosecuted. So there are 61 different rules under very broad headings like applicability, preliminary proceedings, arraignment, grand jury, indictment, venue, and trial. And just as an example, Federal Rule of Criminal Procedure 23 governs some of the particular aspects of how a jury trial works in the federal system. So FR Crim Procedure 23 says that if the defendant is entitled to a jury trial, the only way not to have a trial by jury is if the defendant waives the right, the prosecution accepts the waiver of the right, and the court also approves to the consent waived constitutional guarantee to a trial by jury. So these, again, are very specific standards that give federal prosecutors and federal law enforcement a more specific idea of how exactly they're to go about conducting an investigation than what they would get from the really broad language involved in the constitutional provisions at issue. And so there's a bunch of other ones involving like the size of a jury and many other very specific rules that are involved in the Federal Rules of Criminal Procedure. And there are also, as of course in so many aspects of American politics, state level analogs to the federal rules of criminal procedure that govern prosecution in state matters too, which is of course where the lion's share of prosecutorial activity is taking place is in the states. And indeed, what we talk about today, in particular, the charges that are being leveled against Kramer in his trip to Los Angeles, those are being handled by the Los Angeles Police Department, and presumably California state prosecution would be the sort of follow-up step there, because the sort of crime that he's accused of is not necessarily one that's federal in the context of the show. So this first broad question that we're asking about in light of the Seinfeld two-part episode, The Trip, is what can the police do in an interrogation? So for those of you who saw the episode, the whole gang, and so if you're a Julia Louis-Dreyfus fan, it's sort of unfortunate because Elaine doesn't really play a part in this episode. For whatever reason, she did not make the trip to Los Angeles. But you get the three male members of the Central Four that are out in LA. Jerry and George are trying to convince Kramer to return home after he broke the covenant of the keys so famously. And Kramer is living, he's living the Angelino life. He's running into celebrities and bars. It's all very glamorous, right? He's in this kind of Sunset Boulevard situation in the tenement house that he's renting out, trying to pitch his script to different celebrities. And in the course of his various misadventures, he is suspected of and eventually formally accused of being the Smog Strangler. So this is a serial killer going around Los Angeles, and Kramer, for whatever reason, is mistaken for him. And he's arrested, I believe, at the end of it's a two-part episode, the end of the first part, going to the beginning of the second part is around the time when Kramer is formally taken into custody, but we don't get to see very much in the actual episode of what goes on between the time Kramer is arrested and put in some kind of pretrial detention facility, because we see Kramer have an in-jail conversation with George and Jerry through the phones, the plexiglass. And then after that, we see an interrogation scene, but importantly, we don't ever see the administration of Miranda rights or any point at which Kramer is informed that he has the right to an attorney present subsequent to the formal initiation of judicial proceedings. So this is something that is going to become very important as we talk a little bit. Sorry, we got a cat in screen. As we talk a little bit about the constitutional standards that govern what exactly the police are doing when they take Kramer into custody. So the general debate when we talk about what police are entitled to do constitutionally in the context of an interrogation is one about the use of confessions and evidence, which has been the subject of extensive judicial and popular commentary for a very long time now. And underlying all the cases in this area, we have this tension between the need and indeed the constitutional prerogative to protect individuals against coercive and even brutal, frequently, police force on the one hand, and the perceived need to have a law enforcement system that's not hamstrung in its capacity to conduct effective investigation on the other. So we have a rule that we should exclude evidence, broadly speaking, and this applies in Fourth Amendment contexts in different ways. That's outside of the scope of what we're doing today. But we have all sorts of different prophylactic rules that say evidence illegally obtained shouldn't be admitted. And we know this from the exclusionary rule in the Fourth Amendment context, that if the police violate your rights coming into your home, we have this fruit of the poisonous tree doctrine that says that illegal police conduct, unconstitutional police conduct, shouldn't result in evidence that can be used against the criminally accused subsequently. And that in itself is subject to some controversy, but most people seem to more or less agree on the broad contours. We also then, as kind of an extension of this general principle, exclude coerced statements. So if you're in police interrogation and they're applying the old kind of so-called third degree police torture, the statements that you provide to law enforcement subsequent to that sort of enhanced interrogation is not going to be admissible for 4 reasons. First, as a deterrent. We want to deter future law enforcement from engaging in the same or similar sorts of illegal activity that produced that sort of statement in the first place. Second, as a principle and as a society, we disapprove of techniques that offend a civilized system of justice, and anything amounting to coercive activity on the part of law enforcement is seen as being something that as a society we severely disfavor. Third, because courts are involved in ultimately adjudicating these disputes that arise between prosecutors and criminal defendants, to involve testimonial evidence that came out of coercive activity on the part of the police would also implicate the integrity of the judicial system itself. So we mandate exclusion as a general rule for that reason. And last, we know from a lot of psychological evidence, we can also talk about some of the psychological dimensions of criminal procedure when we get to lineups, that the information coming out of coercive activity or coercive environment is also frequently unreliable. If people are subject to essentially torturous physical or mental pressure on the part of law enforcement, we can't trust what they're saying anyway. So there are all these different dimensions of why we are not really comfortable having this sort of evidence introduced in criminal procedure as general practice. So what Miranda does, we get the Supreme Court ruling in the mid-1960s that gives very specific standards to law enforcement for what they have to do if they take suspects or criminal defendants eventually into what's called custodial interrogation. And this is actually a pretty radical ruling for the time. Like you read, even reading through the language of the decision, for those of you who haven't yet and will someday, perhaps in law school or in practice, you'll see that this uses very sweeping language protecting the rights of the criminally accused that is almost unfamiliar to us as a society now with some of the ways that these issues are ultimately framed. But the Miranda court says that we have to think very carefully about the standards constituting acceptable practice for law enforcement, and broadens the right against self-incrimination to include all custodial interrogation by police outside of what was, prior to this, an excessively formal definition of when suspects and defendants were subject to the whims of law enforcement investigating alleged criminal activity. So the Miranda court says that the defendant's constitutional privilege against self-incrimination means that the admissibility of statements obtained in custodial interrogation, so things that suspects say to the police while they're being questioned, should be governed by a relatively high amount of procedural safeguards. And what are those safeguards? I think we all know them very well from TV and movies, right? You have the right to remain silent. Anything you say can and will be held against you in a court of law. You have a right to an attorney. If you can't afford one, one can be appointed to you. And they're also really supposed to they're supposed to ensure that the suspect or the arrestee is fully aware of what the rights mean, and that they have the right to waive Miranda if they want. So they can talk if they want to, but there are different standards governing the sort of constitutional waiver at issue. So we have a couple of threshold questions then that we have to deal with, including what constitutes police custody, what constitutes an interrogation. In the context of an interrogation, how should Miranda warnings be administered? When Miranda must be invoked, and then what are the exceptions to Miranda? So we'll go through these pretty carefully and then try to wrap it back around and think through how this applies to what's going on with Kramer when he's taken into custody by the LAPD as a suspect in the smog strangling. So custodial interrogation, according to the Miranda court, is questioning initiated by law enforcement after a person has been taken into custody or otherwise deprived of freedom of action in some way. So this deprivation of freedom is something that comes up again and again in the case law when a reasonable person, objectively speaking, doesn't feel free to leave. And that court in Miranda said that the interrogatory environment, so you being under examination, is created for no purpose other than to subjugate the individual to the will of the examiner, and that it doesn't necessarily matter. In fact, it doesn't matter at all if there's no physical force applied, that the mental circumstances themselves can be equally destructive of human dignity. So this is very broad language, really enshrining firmly this protection against self-incrimination. And the notion is that if the police violate the standards set forth by the Supreme Court of Miranda, again, highly, highly technical standards. If you read through the ruling, this is one of these things when you get into kind of broader philosophical debates about what is the scope or what should the scope of judicial review be? What should the power of courts be to read between the lines of the law as it exists textually? What the court was doing in Miranda seems awfully close or tantamount to judicial legislation, right? They come up and they say, well, you have a privilege against self-incrimination, you have a right to an attorney, and you can assert that right. And if the law enforcement doesn't tell you this list of, they literally print this on a card now, for those of you who don't know. So like the police will carry around a card saying what the Miranda rights are, and they're supposed to read them, you know, very formalistically. And we'll get a little bit more later on into how the court has read the formalism requirement in Miranda going forward. But the court has read an awful lot into the Fifth Amendment here and is expecting, and they were correct in expecting this, law enforcement to comply. I mean, within very quickly after the Miranda ruling, this became almost standard accepted operating practice for law enforcement the country over, even at the local level, obviously, where most of this is happening. So Miranda supplies these fairly technical requirements that have to be met if confessions, so inculpatory statements given by the criminally accused, are to be valid. And even if those confessions are made after Miranda has been administered, so even if the police Mirandize the suspect, obtain a confession, that in itself, the administration of Miranda is a necessary but not a sufficient condition to see that the constitutional rights of the criminally accused have been respected. So we have a broader standard called voluntariness that existed before the Miranda case did that says confessions have to be voluntary for the reasons we talked about earlier. We don't want coerced inculpatory material getting into court because we think it's wrong and we don't trust it. So there are ways that under the totality of the circumstances, inculpatory statements given by the criminally accused may be constitutionally inadmissible even if Miranda was applied. So there's a bunch of different moving parts to keep in mind. But one of the main things is in going through, I think it's actually less interesting and less informative to go through exactly, you have the right to remain silent, you have the right to an attorney. We all know that stuff, and there's actually comparatively less dispute as to what that means, and more in terms of what's custodial interrogation. You know, what constitutes police custody, what's interrogation, how do you have to administer the warning? So the most obvious situation, and indeed the one Kramer finds himself in the Seinfeld episode here in season 4, is formal arrest. There's no question if you're formally arrested, taken into custody, that you are in, if you're being questioned then, custodial interrogation. So if you're formally arrested, you need to be Mirandized. The complication comes in the absence of arrest. So there's an objective test for determining custody or the so-called deprivation of freedom that we find in Miranda, right? And courts are supposed to determine how a reasonable person in the position of the suspect would feel and how they would understand their situation. So some things that don't matter are police officers' subjective expectations. If a police officer demonstrated or somehow held an unarticulated plan to arrest the suspect, it doesn't bear on whether or not the suspect was in custody for the purposes of Miranda. Likewise, a suspect's subjective belief that they're in custody or that they are or aren't free to go, to the extent that that's inconsistent with what a reasonable person would think, that also is going to be inadmissible. And that comes from a case where a person under a routine traffic stop was not determined to be in custody for the purposes of Miranda. And as such, the sorts of protections that govern you after Miranda is applied and after that protection attaches didn't apply. So the general rule is that your freedom of movement has to be constrained in some significant way. Again, we don't really have a debate about that in the Seinfeld context. What we wonder about in Seinfeld is whether the rights were administered and whether the administration of the rights was constitutionally sufficient. I'll say more about it in a second. Interrogation can mean a lot of different things, but the most obvious is just questioning. So officers questioning a subject, just like formal arrest is obviously police custody, directly questioning the criminally accused is obviously interrogation. But in some cases, it isn't necessarily clear if statements in response to statements qualify as a response to interrogatory questions. And voluntary statements, certainly, if they're truly voluntary on the part of the accused, are not barred by the Fifth Amendment privilege against self-incrimination. But words or actions on the part of law enforcement that constitute the functional equivalent of questioning, if the police knew or should have known that that sort of action or activity would lead to a response, an inculpatory response on the part of the suspect, is likely to elicit an incriminating response, that sort of activity is going to come under the Miranda definition of interrogation. Police have to administer Miranda right when custodial interrogation begins. And although the Miranda court, if you go back to that decision from the 60s, was adamant that shortcomings and required warnings couldn't be compensated by fixing it later on. So if you forget part of the warnings, you couldn't fill some constitutional deficiency or gap by just saying something later on that papered over whatever you had forgotten to do if you're a police officer arresting somebody. But subsequent courts have been a lot more forgiving in terms of how they regard law enforcement activity. So there's this kind of famous phrase where the court says that they've declined to interpret Miranda as requiring a talismanic incantation of rigid warnings, which is just a very complicated way of saying that they are going to tolerate a higher amount, a greater amount of constitutional deficiencies in how law enforcement questions suspects than what the original Miranda holding would have permitted. So the court said in one case that warnings regarding the right to counsel are adequate, even if you don't say precisely what the Miranda decision says. So if you convey generally to the suspect in a way that an objective person would understand that they had the right to an attorney subsequent to the formal initiation of proceedings, that's enough, and you don't have to read the words from the Miranda decision word for word. So this is an important kind of limitation on the scope of Miranda. But suspects can invoke the right at any time. So the right to remain silent and the right to counsel, you can start exercising it at any time during questioning, even if the criminally accused had initially indicated a voluntary, knowing, and intelligent waiver of the Miranda rights. There are limitations on that too. So courts have said that just staying in one place silently for 3 hours, not talking in the face of police interrogation, if you don't make some affirmative signal that you're invoking your right to remain silent, it doesn't mean that you've invoked Miranda for constitutional purposes. So there are still some ways that law enforcement can find their way around these constitutional guidelines. And in keeping with that, there are also, as with any good legal rule, a long list of exceptions to when the Miranda protections are actually relevant or when they actually adhere. So if the law enforcement officer arresting a suspect deems it necessary for public safety to question them immediately, the existence of a reasonable concern for public safety on the part of the officer, as per some objective determination, actually allows questioning in the absence of Miranda. So in practice, in a fairly large portion of even common investigations, this means that there's no need to Mirandize for law enforcement, according to a lot of courts, immediately after arrest. And so this is a significant gap in what Miranda actually covers. Some less common ones and probably less important ones for practical purposes are general biographical questions asked for in the course of routine booking are not covered by Miranda. And any sort of undercover activity doesn't trigger a constitutional violation if the suspect is unaware they're talking to a law enforcement officer and gives a voluntary statement. So all this together we're not really sure if Kramers' constitutional rights are being violated when he's being questioned by the police officer in the second half of the trip episode. Certainly, the officer is speaking rough. He's making some wild, if you watch it, it's a comedic scene, right? But the officer is making some wild accusations to Kramer. And of course, law enforcement officers are under no legal or constitutional obligation not to deceive the criminally accused, which is another sort of gap in the kind of protections that they enjoy. But without full knowledge of whether or not Kramer was properly, or at least if the administration of Miranda didn't meet some minimum constitutional standards, then there could be a problem because Kramer is being interrogated in what's clearly a custodial setting. He's in pretrial detention. And if Miranda hasn't been administered there, or if Miranda's administered and, Kramer has asked for the namesake of my chair at the Yada Yada Law School, Jackie Childs, to represent him, he's a man of many talents, then Kramer's constitutional rights may well have been violated based on information that we don't have full access to. So that's kind of the general take here. And I look forward in the Q&A to talking a little bit more about what exactly went on in Kramer's time in Los Angeles and what the police and kind of how what the police did here did or didn't comport with our expectations regarding constitutional protections. So one more quick note here is governing a very particular police practice, which is the use of a lineup in investigations. So this is toward the very end of a season 6 episode called The Beard. This is definitely not the A plot for those of you who've done screenwriting classes. But one of the kind of minor strands going on in the Beard episode is that Kramer is brought in as what's called a filler or a foil in a police lineup. So this is a police practice that involves the presentation of potential suspects in a case, and then an alleged eyewitness is brought in and is given, the choice to say which of these guys did it, essentially. You can notice a couple things here about the guys in the picture. There's a couple off to the sides, but we see Kramer's a lot taller, right? He looks like with the hair, it's like coronavirus pandemic hair there. He's almost up to 6'6" with the maximum reach of the hair. And the other guys are a lot shorter. And we know from the end of that episode, this kind of comedic scene, that he's actually triggered because he's pointed out as being the suspect, the perpetrator, even though he's clearly not. And we would wonder then, what exactly were Kramer's legal rights here? He's back in New York, got an NYPD investigation instead of the LAPD. And the main thing that we look at when we're thinking about what constitutional rights are implicated by a police lineup are this trilogy of cases decided in the late 1960s called the Wade Trilogy, which says essentially that the police lineup, is a critical stage of pretrial proceedings. So it passes this standard from a case in the 30s called Powell versus Alabama that said that we need to scrutinize any pretrial confrontation even before a trial to see if the accused has the right to counsel enshrined in the Sixth Amendment. So before this case, the expectation was that you had a right to counsel if you're at trial. But as most of us know, there are so many stages of the criminal process that happen prior to the trial, a jury being impaneled, all of this stuff, and that each of those can be a critical stage at which the right to counsel is so-called attached, right? And the general standard is once the formal initiation of judicial proceedings has taken place, and it can be arraignment, indictment, and information in the states, these components, whether they're formal or informal, in court or out of court, where the counsel's absence might derogate from the accused's rights to a fair trial, are situations where the right to counsel is attached. And as such, the accused has a constitutional right to have an attorney present. So what we're thinking about here is a two-pronged test governing the admissibility of evidence that come out of these lineups. So this is a way of saying that if somebody points out a criminally accused in a lineup, we have to look to two factors, according to the Supreme Court, some cases subsequent to the Wade Trilogy in the 70s, that have us ask two questions. First is whether or not the identification procedure used by law enforcement was suggestive. So that means does something in the construction or the administration of the lineup lead the alleged eyewitness to point a finger at some defendant, some suspect, in a way that was unduly suggestive? Was there only one person of the race that the alleged eyewitness had had proffered as being the race of the perpetrator in the lineup, which would obviously suggest that they're going to pick that person. So there are ways that law enforcement can load the dice, stack the deck, whatever metaphor you like, to make it more or less obvious that one person is the focus or the target of the investigation. And so at first we ask, is the procedure used for identification by the police suggestive? If it's not a suggestive practice, then we can admit the evidence. But if it is, then we have to look a little bit more carefully, and courts are under the obligation to determine whether other circumstances used in the identification indicate that the identification by the eyewitness is reliable or not. So it leads us to a lot of interesting factors. And this is, again, kind of getting into something which is certainly not my specialty, which is psychology, kind of psychology and law. But the rules governing lineup composition and construction lead us to wonder different sorts of questions like how members should be selected, how many members should there be on a panel, should the presentation of the potential suspects be live, by video, by static photograph, should the presentation occur sequentially, one after the other, or simultaneously, like we see in the Seinfeld context. And of course, our main cause for concern here is that we could have false identification errors that subsequently beget false convictions. So, like I said, the people who are not the criminally accused but appear in a lineup are called either fillers or foils or different words. And we have this situation of foil similarity and a question of how close is close enough. You know, like how close do the foils on the lineup have to be to the physical characteristics of the person that was initially suspected to meet minimum constitutional standards. And there have been cases in the 60s where the Supreme Court reversed the conviction of somebody because they were 6 feet participating in a lineup, 6 feet tall, like Kramer in that one, and all the other people in the lineup were under 5'6". So nobody else could reasonably have been the criminal suspect. But then simultaneously, this is an area where you definitely have some ambiguity in what the Supreme Court has said, because in a case in the 70s, they held that there's no requirement, no constitutional requirement in police lineups that the accused should be surrounded by people who are identical or nearly identical in appearance. And the United States Department of Justice guidelines for federal prosecutors say that the suspect only shouldn't unduly stand out. So the basic test seems to be whether or not a person who wasn't a witness and has no memory of the alleged criminal activity should not be able to identify the suspect. So if we increase foil similarity, there are benefits and costs. We avoid false identifications, but then also might diminish some of our correct identifications as well. So it's a difficult trade-off. There's a lot of really interesting research in experimental psychology looking at kind of whether sequential or simultaneous presentation increases, I guess, type 1 or type 2 error and other questions like that. But as we get back to Seinfeld and think through what went on with Kramer here, we have to suspend disbelief for a second, as always with fiction, because we know that Kramer didn't actually do anything wrong, at least nothing that he's being accused of here. But if he was indeed targeted by an eyewitness here, I think he would have a reasonable challenge under the Foster versus California standard due to the discrepancy in height. So if Kramer actually is the suspect of a crime that the cops are looking to ID, and he's put on a lineup with a bunch of people who are a full foot shorter than him, I think there's a pretty good chance that he could have this lineup identification thrown out. So just to kind of wrap up, we have this kind of fun scene at the end of the trip where Kramer, George, and Jerry are celebrating Kramer being exonerated, because if you watch the episode, right at the end of that kind of tough as nails interrogation scene, the LAPD gets a call and they hear there's another murder. And so these guys go out on the steps and they dance around in like true Seinfeldian fashion. And they say, we're free, because the murderer struck again, right in front of the LA courthouse. So to conclude some things about criminal procedure here, I want to kind of reinforce what I said at the top of the hour, which is that it may be easy to present this in the popular press as individuals getting off on a technicality or exploiting some aspect of the legal system in a way that exonerates them unfairly. But I think what I tried to establish here, as we think carefully through what can police do in the context of custodial interrogation, questioning a witness, how can police induce some sort of eyewitness identification through a lineup or a show-up process? These are foundational constitutional rights that are being protected by criminal defense attorneys, and not merely some technicality that allows people to get off because the system is intending to be soft on crime. So the centrality of these constitutional protections to the standards governing police and prosecutorial conduct are not things that we should be abandoning with any sort of thoughtlessness. So that's kind of where I am at. I want to remind everybody again to donate if you can to Legal Services New York City to support their relief efforts against the coronavirus. And with the remaining minutes here, I look forward to hearing from those of you who might have questions.
So hi, everyone. Thank you so much, Professor Carr Peterson, for that very interesting talk on criminal procedural law. My name is Cesar Rosado, and I will be moderating the rest of this webinar. Please, everyone, if you haven't done so already, send your questions through the chat menu. I will be reading, and I've been collecting some of those questions already, and I will be voicing them over through, through the system now. So, I'll be, waiting for them as they come along. But the first question, very interesting one here is, remember in the video, the police got close, personal, even insulting with Kramer. Is that okay?
Yeah, that's a good question. That's one that I was sort of wrestling with. I actually rewatched the episode this morning, and I was trying to see, we don't really get a ton of particular statements on verbal abuse from the police in the cases that I've read. We know that physical intimidation is not going to be constitutionally okay, right? Like, we know that they can't go in and beat somebody up, at least not anymore. They did for hundreds of years. But in terms of the verbal abuse, I think that this probably, I don't know from a moral perspective, but from a legal perspective would probably slide. If you think about it, it's certainly going to be emotionally damaging to somebody to have somebody screaming in their face, making false accusations. But to the extent that we have jurisprudence on the matter, we know that making false representations to the criminally accused is something that doesn't violate the constitutional protections afforded criminal defendants according to the Supreme Court. So as far as I can see it, I'm not sure that just essentially micromanaging the police based on their tone is something that courts would step in and put a stop to, even if obviously I think they probably should. But from the cases that I've seen and from my exposure to just kind of in practice, the way these sorts of things work on the part of prosecutors is that they're allowed very broad latitude to administer questions in the context of interrogations, provided they've taken the right preliminary steps pursuant to the prophylactic rules that have been issued by the Supreme Court, in particular in Miranda. But they can't do anything abusive. The question would be, at what point does the police questioning of a suspect cross some sort of legal line? In one case you can think of, there's a case called Spano versus New York, where a young man who had been born in Italy was brought to the US and then underwent like hours and hours of extremely coercive questioning, was held to have his constitutional rights violated due to the manner in which he was questioned. And that didn't involve any like real physical deprivation, and it was mostly kind of emotional. And it took into account the kind of subjective factors in his personal background to make a determination of the constitutional violation there. So if you can make a case that the questioning was coercive to the person, I think that there's a good argument to be made that some constitutional problem exists. The issue with Seinfeld, of course, is that Kramer doesn't really seem like a wilting flower. And if you can't identify some kind of subjective vulnerability on the part of the person being questioned, you're probably less likely to win if you're challenging it, which isn't to say that objectively what they were doing is okay.
Great. So here's another question. Let's say that Kramer's case went to trial and that lineup was thrown out. What about everything that would have happened afterwards? For example, if the police got a warrant to search a home as a result of that lineup.
Well, so just to be clear, the lineup is from a separate episode. It's not from the Smog Strangler episode. So Kramer wasn't actually identified by a lineup in the Smog Strangler episode. The lineup is involving a separate investigation, and Kramer's at the police. The kind of backstory is Kramer's at the police station with Jerry for unrelated purposes. and Kramer takes an offer to be a foil or a filler in a lineup. So Kramer is actually not suspected of any criminal activity by the police in the Beard episode. So the fact that he's identified by an eyewitness is not consistent with or corroborated by any sort of evidence at all in the Beard episode, because they're investigating an unrelated crime. But if we're thinking about it, like if we're thinking about, had there been in some imaginary world a lineup in the Smog Strangler case, and you have Kramer a foot taller than everybody else, somebody points him out as the Smog Strangler, and you have a bunch of other corroborating evidence consistent with the police's theory of the case independently out there, like we did in the Smog Strangler, it may induce the courts to look a little bit differently at what went on in the lineup practice. Because we know what the standards are, right? Even though the Supreme Court threw out a case where somebody was of a vastly different height than the people on the lineup with them, than the foils on the lineup with them, we know that the Supreme Court said subsequently to that, that we asked whether the process was suggestive. And if we say yes, so we'll assume a court says yes, it's suggestive to have Kramer looking a foot taller than everybody else. Then we look at other objective indicia of whether or not this was a reliable identification. So it may be easy, relatively easy, for the prosecutors to paper over any other constitutional deficiency in terms of the lineup construction if they can point to other factors that would have led an eyewitness to identify Kramer in the given case.
Okay, so great. So here's another question. You mentioned that a traffic stop may not constitute custody. Can you expound? I'm imagining all the times I've been pulled over, can't really get out of my car, cannot stop. And I've always been asked, do you know why I pulled you over? A cop asking me that seems to be soliciting self-incrimination.
Yeah, so that's a really good question. So there's a long list of factors that include both subjective and objective components that have been used kind of over time by courts. We've kind of aggregated together this list of contributing factors that we can use to make a determination as to whether somebody's in custodial interrogation. I think that in the context of the traffic stop, the reason that the Supreme Court in particular said that the defendant or the suspect in question was not subject to custodial interrogation was partially the setting. So being in your own car, your own physical property, out, on a street somewhere rather than in a police station is not particularly indicative of a situation where you're at the total control of the police. And likewise, the duration is another factor that courts have looked into and considered when they're determining whether or not the kind of protections attendant custodial interrogation have attached or not. But having said that, I certainly take your point and I think agree with you that most people, if we're really worried about what does a reasonable person think, especially knowing more or less what we know about what are conventional and standard police practices, if you're pulled over by the police and they're standing at your window, turn your engine off, turn the radio down, do you feel free to leave? I certainly wouldn't either. So I take your point.
So another question here, and this is, I'm taking my authority here as moderator. When it comes to terrorists, somebody is suspected of terrorism and perhaps under the Patriot Act or something like that, do those kinds of folks, if they get detained by police or law enforcement, do they get the same Miranda rights?
So presuming that these guys in law enforcement are working on the soil within their local or state jurisdiction, whatever, the Miranda warnings apply. But the one sort of thing that I'd point us to is the public safety exception. So in some ways, a lot of critics of the public safety exception to the administration of Miranda consider this like the exception that swallows the rule, right? Like that if the law enforcement can come up with some reasonable set of circumstances that would lead an objective officer to consider a threat to public safety if they don't question somebody prior to Mirandizing them, then courts are going to let any kind of testimonial evidence that comes subsequent to that interrogation be admitted. And certainly something as dramatic as what you're describing, terrorism, Patriot Act stuff, that sounds like exactly the sort of red meat that a court would seize on in terms of granting a public safety exception to Miranda. So yes, but maybe not really.
Okay. And so there's also this question of whether or not social change through the years, has that in any way changed the way we view Miranda rights?
Yeah, so it's an interesting question, the sort of development between the doctrine, the Miranda Doctrine, which is so triumphantly announced in the mid-60s, and the way that it's regarded now and has been treated over time. My reading, I'm not an expert in public opinion either, but it seems to me, especially if we consider stuff going on recently, that over time, it may be that the public, broadly speaking, has actually become, I think, more accepting of the sorts of protections initiated by Miranda, but that courts countervailingly have been chipping away at how far Miranda goes and when it applies, like how much in substantive terms it actually protects. So I think that, and like part of this can just be chalked up probably to like lack of awareness. Like I don't think that most people out there are tracking the development of Miranda jurisprudence over time and saying like, wow, it looks like the court's creating all these exceptions that law enforcement can very easily lean on to admit evidence from an interrogation that they were doing in a context where they should have Mirandized somebody. But maybe this is something that like we have all these different kind of social movements for criminal justice reform now, but Miranda probably isn't like a big ticket item on those, like re-articulating or re-announcing or reaffirming the central holding in Miranda is probably relatively low on the list of problems right now, but it's something that should be considered, kind of the extent to which that decision is still operational. Because, you know, the court says very clearly initially, these are the protections that criminally accused people need to be made aware of. And now we're in a situation where the court has given us a laundry list of situations where deficiencies in the administration of Miranda don't jeopardize the subsequent admission of the evidence gathered in violation of Miranda. So it's something we should consider. I don't know how closely Miranda itself and that set of warnings, kind of protection against self-incrimination, is tied in with the social movements, but I think it's something that we should certainly remain aware of and make people more aware of.
Great, and so we have time for one other question, relatively simple. It seems a question just to clarify some things here. So is a photo lineup held before charging of a suspect subject to the same rules?
Yeah, so photo lineups, which I think are called show-ups in some places, where they have like a thing of photographs, they're governed by the same standards in terms of construction and constitution as the lineups are. Physical lineups in person. And there's a lot of debate in the psychology literature in this as to whether or not it's more or less reliable to have photos versus in-person identification. I think the general rule is that most people prefer in-person identification. Like in the same way when I get my list of students every semester and I see their ID pictures on the roster and I am literally unable to identify more than 5 of them based on their ID card pictures, I think for these kind of different reasons, like psychic deficiencies that we have identifying in-person individuals based on photographs, the preference is to have in-person identification in a lineup. But in terms of the constitutional standards, they're governed by pretty much the same doctrine.
Fabulous. Well, with that, we have to close the session for today. Before everyone goes, remember to donate for the charity that we have chosen for this activity. And also, I would like to remind everyone that as the Monk's Chair in Socio-Legal Studies, I will be presenting next week on contracts and employment. So please tune in for that webinar. Thank you to everybody.
Great, thanks everyone. That concludes the first class for today. We're going to take a 3-minute break before starting our second class in the doubleheader, Seinfeld Constitutional Law, taught by Professor Anthony Michael Christ. So please rejoin us on the hour. Thanks.